Now, one person we did hear from today for the first time, Karen Read herself, doubling down, of course, saying she did not do this. She wants to know who did.
Said it feels we're the only ones fighting for the truth of what happened to John O'Keefe. And me and my family and my attorneys and my team have marshaled every resource to get to the truth. It just feels like no one else wants it.
Karen, just to be clear, you didn't do it.
We know who did it, Steve. We know. And we know who spearheaded this cover-up. You all know.
Yes, we do.
And no, she didn't do it. No, she didn't do it. This is an innocent woman. She didn't do it.
I tried to save his life.
Yeah.
I tried to save his life at 6 in the morning. I was covered in the only one trying to save his life.
Why'd you admit to it?
She didn't admit to it. She didn't admit to anything close to that. Nothing close to that. And you should know that.
That was like 3 or 4 times she admitted to it.
No, she didn't.
That's not true.
She asked a question. She asked a question, which is very different. She didn't admit to anything.
You are listening to the Roberta Glass True Crime Report, putting the true back in true crime. From New York City, Roberta Glass is now on the record.
Okay. How is everybody? Here we go. Another live show. Is everybody ready? Wanted to talk about Gretchen Voss today and why she is planning to fight the latest ruling. Will it be successful? What Karen Read told her, why she's fighting this latest ruling. We got some snippets of what Karen Read actually told Gretchen Voss in the redacted, some of the leaked segments of this redacted interview. But if you remember back, Hank Brennan was saying, like, look, there's over 150 redactions here. Anybody remember that argument? Maybe we'll go back. Let me pull it up if I can. The last hearing we were talking about. And Hank Brennan was asking for everything from everyone. All these Dateline, Ted Daniel interview, everything's coming in. The Judge Canoni ruled today, it all can come in. So if you missed what I said, I'm kind of bearing the lead here. Everything's coming in. If they can get it and present it as evidence, it's coming in. Anything said off the record, Gretchen Voss's notes. Gretchen Voss says she's vowing to fight it. But what it's going to show, what's going to be most damning. So do I think that there is a bombshell in this Gretchen Voss interview? No. However, I think it's the first major interview that Karen Read did. And I think it's going to contradict, it's before she really refined her innocence fraud grift and her innocence fraud narrative. And I think it's going to contradict a lot of the later interviews. And that's what's going to be so damaging to Karen Read, is all the contradictions. Here's Karen Read telling this story. Here she is telling this story. Here she is telling yet another story. You know who does this? Jurors? Liars. That's what their jurors are going to be thinking to themselves. If we have a fair jury, again, I'll say it again, the most important thing is how the jury is picked. If we have 2 free Karen readers, 3 free Karen readers on the jury this time over, it's going to be a disaster. It's going to be a hung jury or a full acquittal. Because I would say that maybe they're going to do some smaller, lesser charge. Doubtful. Doubtful. They don't want Karen Reed convicted of anything. So let's take a look at Hank Brennan together. So here he is making some arguments about the phones.
Pleadings relative to the Boston Magazine and Ms. Voss information. And I've had the benefit of observing numerous other statements that have been made by Ms. Reed publicly. And I've been able to contrast and compare the statements made to Ms. Voss as well as the statements made to a number of other media organizations, including Dateline, 2020, Vanity Fair. And after a review of all those materials.
So here's Hank Brennan, who's the specially appointed prosecutor. He defended Whitey Bulger. Here he's saying, I've already contrasted what we have, which is the redacted interview, and it's already contradicting her later interviews.
It is clear that there is significant materials that were not turned over to the Commonwealth that are relevant material and substantive evidence in this case. In listening to the past hearing, the position of Boston Magazine was that almost everything was entirely on record and that there were a few interchanges by the attorneys. Not only did I have an opportunity to read the Boston Magazine article and listen to the interviews, but I had them transcribed.
So some of what Gretchen Voss's argument was, here's Hank Brennan saying it, was that you already have it all. The only thing that was left out was just some exchanges between the attorneys. But we know that can't be true because, and Gretchen Voss and her lawyers are arguing that because first time round, Lally didn't want the exchanges between the lawyers. This time, Hank Brennan wants those exchanges between those lawyers. So it's very clever of them to say, oh, you know what? The redactions, you're not missing much. Just a few exchanges between the lawyers. Nothing. And if we do unredact these documents, it's going to have so many implications for Gretchen Voss in her own life. She cannot withstand the harassment, which we know is untrue because Gretchen Voss appeared every day at Karen Reed's trial. Did she write anything? Not under her own name, she didn't. What was she doing at the trial? Was she just gathering up notes for her Netflix feature? So I tend to hone in. We're going to look at Ted Daniels and his interview with the parents, Karen Reed's parents too today. But I tend to really hone in on Gretchen Voss because I find it particularly distasteful and repellent what she's doing, which is here we have a second-degree murder case, and she's saying, oh no, she's treating Karen Reed like she's protecting Karen Reed, not helping the family. And her first piece, I love how Turtle Boy turned it all around and was like, oh, this is a pro O'Keefe family, Karen Reed is guilty article. No, it's not. She didn't talk to any members of the family. She talked to Karen Reed and her lawyers and Turtle Boy. And it became Karen Reed's narrative of that night. And even on this side of the aisle, if you stray at all from the Gretchen Voss narrative at all, people don't like it. It's like we're contained to this very narrow view of this case. So I don't like what she did here. I don't understand why she considers her handwritten notes and her redactions so important in terms, and why she considers John O'Keefe's and getting justice life and getting justice for what happened to John O'Keefe so unimportant. She's not a secret source. She's not a confidential source. There is nothing in Massachusetts law that says that she doesn't have to hand this over. And I would be really surprised if Boston Magazine pays for her lawyers to continue to fight this. She really doesn't have a leg to stand on here.
Have a copy for the court if the court pleases.
Yeah, that would be helpful.
And there were two different interviews that were turned over. One was represented at the last hearing, that it was 4 hours long. The Commonwealth received 3 hours and 19 minutes. It's missing, not a little bit, a significant portion of that hearing, 40 minutes. The second interview was represented in the audio recording of court that I listened to as a 2-hour interview. The Commonwealth received merely 19 minutes.
So, right. So there's some argument about the second interview. First interview is 3 hours. And did you guys hear what that was? I missed it. It was like, I want to say 19 minutes, but it could be 19 minutes all together. Did I mishear? Hold on, let me go back and listen one more time. But the 40 minutes are redacted. Second time, it's either a 2-hour or 1-hour interview, and she handed over 19 minutes. So if it's 2 hours and handing over 2 hours, there's more redactions. Either way, on the second interview, taped interview, audio interview, there's more redactions than there is actual interview handed over. Whether it's 2 hours or 1 hour. Thanks, Pilgrim Shadow. Thanks for supporting the channel and becoming a new member. Appreciate it.
And after a review of all those materials, it is clear that there is significant materials that were not turned over to the Commonwealth that are relevant material and substantive evidence in this case. In listening to the past hearing, the position of Boston Magazine was that almost everything was entirely on record and that there were a few interchanges by the attorneys. Not only did I have an opportunity to read the Boston Magazine article and listen to the interviews, but I had them transcribed, have a copy for the court if the court pleases.
Yeah, that would be helpful.
And there were two different interviews that were turned over. One was represented at the last hearing, that it was 4 hours long. The Commonwealth received 3 hours and 19 minutes. It's missing, not a little bit, a significant portion of that hearing, 40 minutes. The second interview was represented in the audio recording.
Okay, so 19 is the magic number here. So the first interview was 4 hours long, and they handed over 3 hours and 19 minutes. So there's good deal redacted. 40 minutes redacted. Second interview is where she hands over 19 minutes, or Boston Magazine hands over 19 minutes and redacts all the rest of it, whether it's an hour or 2 hours. Brennan seems pretty certain it's 2 hours, but let's see.
Recording of court that I listened to as a 2-hour interview. The Commonwealth received merely 19 minutes. So the majority of that interview was not provided. And so there wasn't just a few redactions. They were significant. In addition, which is notable, and you can glean this from the transcripts.
This hearing, hey Jude is asking question, when was this hearing? It's right before Thanksgiving. A day or two before Thanksgiving. So I have some of those exchanges with the redactions. We'll go over them.
Is that there wasn't just a few interruptions. Mr. Yannetti is noted on the transcript 37 times, Attorney Little 33 times, and Attorney Jackson 33 times. And so there are significant interruptions and redactions in both recordings. These redactions in the recordings are important. One thing that stands out when you actually listen to the interviews and you look at the transcripts is that many times during the attorney's interruptions, there's a redaction, and then when the conversation resumes, there is a change, sometimes subtle, sometimes not so. There is a change in the statement by Ms. Reed. And so it is clear that there is an inference that in those redacted portions there is conversation or consultation or discussion happening that changes the direction and sometimes the content of Ms. Reed's statements.
So that's going to be really interesting. So what he's saying is, with Yannetti and Alan Jackson by her side, Karen Reed gave this interview. She would make a statement, and then the lawyers would interject, and then her statement would be changed because, of course, they're trying to legally protect her from just the scenario. It worked the first trial. None of this was admissible the first trial. Didn't come in. So they're trying to protect her because they want to spearhead an innocence fraud campaign pre-trial, but they don't want it to hurt Karen Reed. Worked the first time, not so much this time.
That bears directly on the credibility of the witness. Because be mindful, all of her statements are admissible. All of them. They're all substantive evidence. There's no hearsay. There's no limitation. They are statements of a defendant. They're material and relevant, and the Commonwealth is free to use any and all of them at their discretion. And so it's not only what she says in the interview, it is what is missing in the redactions. Now, certainly, there may be discussions in those redactions that involve her attorneys and Ms. Voss. But none of that is protected. None of that is protected. A defendant enjoys many privileges, but when an accused decides to cast aside their privileges, they don't get to add their own layer of protection. There's absolutely no basis in our jurisprudence for a defendant to be able to do that. They enjoy a Fifth Amendment privilege as they should. A defendant is presumed innocent. But when they cast it aside, it's at their own peril. They have an attorney-client privilege. But when they...
Again, I'll make this point again. The best thing you can do if you are arrested, charged with a crime, is to keep your mouth closed and get a lawyer. Everyone knows not to speak to law enforcement without a lawyer. Many people think that they're going to, especially if you're guilty, talk their way out of it, and they end up confessing. Wait till here he says, absolutely, she has a Fifth Amendment right not to incriminate herself. But once she casts that aside, she does that at her own peril, Karen Reed. But why would she want to cast aside such an important right? Well, it's pretty obvious, because she felt that starting an innocence fraud campaign was much more valuable, and getting her fake narrative out in the story pre-trial would poison the jury pool. And I believe her whole purpose of hiring Yannetti, what Yannetti is really known for, and is good at, is getting your case thrown out pre-trial. Go look at his website, and he has a list of all of his cases thrown out pre-trial, deal made with the Commonwealth, thrown out. So this was never supposed to go to trial. And she gambled and she lost. It went to trial. She got a hung jury, which is usually gives defendants a false sense of confidence, because a hung jury is really good for the state and not so good for defendants. Second time round, they often get convicted. Thinking of Rabbi Newlander's one, just died recently, killed his wife, first time got a hung jury, second time was convicted very easily.
The attorney-client privilege by speaking in front of a third party that's not part of the prosecution team, that privilege no longer exists. It dies. And there is no reporter privilege in Massachusetts. And so what has happened in this interview is that we have 3 attorneys, a defendant, and a reporter having a free reign of interview, and then later deciding what parts of the interview they want the public to hear, what parts of the interview they want the Commonwealth to have possession of. They don't have, respectfully, that choice or that power or that discretion. They can contract with each other, have their own side agreements and what they want about on and off the record, but it doesn't bind the Commonwealth. It never has, it never will. We don't agree to it. And so what we have is many instances and examples where those redacted portions are critical to understanding why the story at times changes after the redactions. And so I think of it this way. If Ms. Voss was called to testify by the Commonwealth at trial, and we have her on the stand, and I was to say to her, I've received your recordings and your redactions, and I've read your article, Ms. Voss. I want to ask you about the conversation after Ms. Reed talks about sipping drinks at the waterfall, and it's redacted. I want you to tell me what she said. There could be no objection for the defense that there's a private agreement. There could be no objection from the defense that somehow it's privileged. She would have to answer the question, this is what Karen Reed told me. So to suggest that pre-trial, somehow they can have this protection that doesn't exist in reality in the law, to protect statements that the defendant or their attorneys made that they don't want the Commonwealth to learn about, is just wishful thinking. That's all it is. And, you know, I'm not oblivious to the fact that there are a number of statements that are made that are redacted to Ms. Voss where the defense attorneys are present in the room. There is no attorney-client privilege at that point. There's none. Arguably, all three of the attorneys are witnesses as well.
This is an interesting thing also. If they try again, I hope Brennan tries again for Karen Reed's parents' phone. If there was a phone conversation between a lawyer and Karen Reed and her father, that's no longer privileged. So interestingly, he's saying here, Brennan, making the argument that it's not privileged, it just because her lawyers were at her side. So this is 100% about Gretchen Voss. And for whatever reason, perhaps wanting to change the laws in Massachusetts regarding handing over notes, but she may be wanting to fight this to make a precedence with her case. But good luck. I mean, you never know in very liberal Massachusetts, maybe it'll fly, but I don't see it. This has just been silly and ridiculous. She should have wanted to hand over everything she had to do anything she could do to help. And, you know, not for nothing, but when it comes to Karen Reed, if she's so innocent, all her words, it should all be exculpatory for Karen Reed. Anything she said, she should have one story because the truth never changes and sticks to it. And I'm not talking about like small details change. Everyone tells the story a little bit different from the first time or a second time or a third time. I'm talking about significant details of her story have changed from telling Gretchen Voss that she drank not at all. If you saw the thumbnail, she didn't have any drinks the second time, second bar, the waterfall. She just sipped on water, which may have gotten the idea from one of the women she was out with who testified, who said she was sipping on water. Maybe that's where Karen Reed got that idea. Who knows? That she had nothing and that she was not drunk at all. Nobody thought she was that drunk, including the bartender. We'll get into her statements with Gretchen Voss in a second. But my point is, and I do believe Karen Reed when she says no one thought she was that drunk, because certainly the morning after, no one thought she was that drunk, and she tested way over the limit. I think she's a habitual drinker, and alcohol doesn't touch the sides. None of the police officers said she stank like liquor and was so out of her mind, intoxicated. Go back to the testimony. We know it now from the results. Hold on. From the results of her DUI test, in the hospital, because she was sectioned, which I think that was very cleverly done by her father to keep her away from being questioned by the police. But nobody said that morning, thought that morning or that evening that she was so drunk.
Now, Commonwealth is not heavy-handed. The Commonwealth does not want to disrupt the defense team. The Commonwealth does not want to delay this trial. The Commonwealth does not want to put an attorney in an uncomfortable position. But they're all witnesses to a substantive statement, many of them admissions of guilt, contradictions, all of them, in the most respectful way to pursue those, the strongest way, the fairest way to pursue those, with moderation, is to get them from Emily Voss in the interview that exists. Now, in the pleadings, I received the response this morning. I didn't get to read the entire thing. I have no objection to it. But I did listen to the hearing. And it strikes me that the argument of the newspaper company was primarily based on two propositions. Number one, Commonwealth versus Doe, promulgation, those cases.
Okay, I think we get the idea. I think we get the idea. So looking at Karen Reed, so what did she tell Gretchen Voss, the subject of today's episode? Well, we know a little bit from the legal filings. And I'm just going to share my screen. And this was put into a blog by Innocence Fraud Watch, June 2023. Gretchen Voss interviewed Karen Reed on June 20th. This interview was audio recorded and lasted around 4 hours. Karen's attorneys were present throughout the interview. During this interview, Karen Reed lied about the night of January 28th, 2022, and stated that she had like a vodka tonic every 40 minutes. Surveillance camera footage from C.F. McCarthy's pub evidences the fact that Karen Reed was drinking a unit of vodka an average of around every 12 minutes. During the interview, Karen Reed also told Gretchen Voss that she claimed to consume sips of water at the waterfall. Below are extracts from the Commonwealth's renewed motion for all audio recordings, interviews, notes, emails, text messages, and voicemails in the possession of Gretchen Voss and or MetroCorp. So the link to this is in the description of this episode if you guys want to read the whole blog. In her June 20th, 2023 interview, and the reason I'm reading this and not the Commonwealth's renewed motion is because Innocence Fraud Watch put this together very nicely. So into a kind of, in a way that you can tell who's speaking and who's answering here. Karen Reed, okay, in her June 20th, 2023 interview with Voss, the defendant professed, here's Karen Reed talking, drinking like I normally would. I tend to talk a lot when I'm out in those, and people see the bar footage. I'm very much in the middle of a group, and Liza's seen it too. This is at McCarthy's and at the second bar as well that I used to stop drinking, And, you know, I'm very extroverted around people when I'm in that environment, but we weren't redaction. You weren't what, Karen? Wouldn't you want to know what she said there? Redacted. I would love to take bets on what some of these redacted words are, but we weren't hammered. We weren't drunk. We weren't, what do you think goes there? David Yannetti says, well, you, and Karen Reed says, yeah, in my 20s, the defendant discusses medical issues. The redaction interrupts the defendant. This is the Commonwealth talking. The defendant's admissions on a crucial issue, her drinking alcohol on the night in question. When the redacted audio resumes, the discussion has shifted from consumption of alcohol to a medical issue. Further, in her June 20th, 2023 interview, the defendant makes more admissions relating to the issue of alcohol consumption. Gretchen Voss says or asks, and is the level of intoxication pretty high here for everybody? Karen Reed, it's happy. So that's an interesting association with high levels of intoxication with happiness. Gretchen Voss says, yeah. Karen, Gretchen Voss says, because you've had a lot to drink, right? This is something that, she's kind of prompting Karen to say she had a lot to drink. And Karen's resisting here. Karen says, I wouldn't say I had like a normal amount. Okay, what's a normal amount of alcohol? Gretchen Voss asks, what's normal? Karen Reed, like a vodka tonic every 40 minutes. Gretchen Voss says, okay. And so are you feeling like buzzed? And I'm not judging you. I'm just trying to get a sense. Karen Reed, yeah, buzzed. And then she quotes her as saying, Karen Reed saying, I was buzzed. But those are really Gretchen Voss's words. Hold on one second. I got a cough. Shortly after these admissions, the interview continues. Gretchen Voss, yeah, okay. So the Jen's trying to get you to go and you are insisting I'm leaving with John, redaction. I was reading redaction and John at the same time and I got Don. I'm leaving with John and there's another redaction. Karen Reed, yeah, I had a water. I had sips of water at Waterfall. Yeah, but I hasn't had anything to drink before about 9:15 that night. Everyone I met up with that night had been drinking long before. So she's trying to say, because I came in late, because I was dealing with my Richie the plumber issues. Anybody remember that? Karen Reed telling John O'Keefe that she couldn't come out that night right away because her hot water was messed up in her house and she had to wait for Richie the plumber to fix it. Was she trying to make him jealous? Wouldn't the first thing you ask Karen Reed when she comes into the bar that night is, how did you get on with the plumber? John O'Keefe told her to just leave it, and his father, who is a plumber, would come fix it for free. But I really think she was baiting him with those plumber issues. I have to be alone with a strange man in my house till late, and then I'll meet you after I'm finished dealing with this strange man in my house who's going to fix my plumbing that you could easily have fixed with your father for free if I had just asked you or waited or done both. Gretchen Voss, yeah. So Karen Reed says, so I went out. I would assume their level of intoxication was higher than mine because she came in late. The defendant's admission of drinking alcohol. Hold on one second, guys. Okay, the defendant's admission of drinking a vodka tonic every 40 minutes is followed by a redaction shortly after. Okay, Karen Reed, I probably had about, but she told, in another interview, she told the interviewer on 2020 that she probably had about 4, and not 4 that I completed either. I didn't drink maybe 4, more than a few sips at the Waterfall. So there we already have a contradiction in interviews. Voss refers to the bartender at the Waterfall in the evening of the alleged collision and questions. Here's Gretchen Voss, and they're talking about the bartender. She said to me that we never served her. So Gretchen Voss is saying, I talked to that bartender that night, and she said that she never served you. And Karen, this will come up in the civil case that the O'Keeffes have against the Waterfall Bar and Grill and Karen Reed for causing the untimely death of John O'Keefe. Karen Reed says they didn't. Alan Jackson says never said, never served her. That's weird. Karen Reed says, I didn't drink there. So she's very certain that she didn't drink. Okay, then I need to go back. For some reason, I thought they had like your drinks by the time. Karen Reed, I was at a bar before and they knew by the bills. So she's trying to tailor her story to the evidence. Gretchen Voss, the bar before. Karen Reed, but I didn't really drink at the second bar. I just socialized. And the same girl, she's heavy? Gretchen Voss, yeah. There are like only 2 bartenders. That's the owner's daughter. Karen Reed says she knows both of the bartenders. Gretchen Voss says she's gruff, talking about this bartender. Karen Reed says she testified before the grand jury that I didn't appear drunk. Join the club of everyone who didn't think Karen Reed appeared drunk that night or that morning after. I was talking. I was fine. Here's an interesting admission in the negative. There was no arguing, and no, she didn't serve me. So is she trying, and this is something that her parents do, try to make out that her relationship with John O'Keefe was great at the time when we know it wasn't, and that there were heavy tensions in their relationship. But it's very important to Karen Reed to tell you that there was no arguing that night, and she wasn't served. I never went to the bar. Gretchen Voss, yeah, okay, interesting. She never went to the bar because John O'Keefe was getting her drinks, I believe. Oh, okay, all right. Redaction, we were at both places for 90 minutes, so 90 minutes at the end of the night with no alcohol. Right, so she's trying to say I sobered up by not drinking at the end of the night before I drove. Right, and there's another redaction. Karen Reed says, I told her that we were redacted. Yeah, she said 3. Did you hear that? Redaction. So that'll give you an idea. According to the October, Karen Reed had stated, I didn't drink there. I didn't really drink at the second bar. I just socialized. Here's Gretchen Voss at the Rolling Rally. So that'll give you an idea of some of the things that she said. But what a thing to say. Like, I came in late, so they were all way drunker than I was. We don't know what she was doing at her home beforehand. She could have been drinking all day for all we know. I mean, there's just not a lot of information about John O'Keefe's full whereabouts that whole day either, where exactly he came from. And I know that he had a doctor's appointment with his niece or nephew. And of course, the testimony of John Camerano, but the actual, mechanics of how that all where they were every moment of the day, we are still yet to be discovered. So that's that. Let's look a little bit at interesting part of the new motion. Actually, you know what? I'm reading an awful lot. Let's go. Let's go to Karen Reed. So one of the things that's coming in, this is what we all saw. Boston 25 interview with Ted Daniel. It's coming in. The whole 2-hour interview with Karen Reed's parents and Karen Reed's brother. This is what was presented to the public. Thought it would be a good time to take a look at it.
Beaten in a basement, dragged out through a bulkhead, and left in a snowstorm to die in the cold.
That's how Karen Reed's family claims John O'Keefe was killed in the town of Canton. They shared that theory with 25 Investigates reporter Ted Daniel.
Ted spoke to Reed's parents for nearly 2 hours about their fight to prove their daughter's innocence.
It seems logical that police would have looked at Karen Reed as a possible suspect. One of her taillights.
So how many parents actually stand up and say, my son or daughter did it in these kind of cases? Very few. I can only think of one, Justin Brooks's mother, but she didn't come to the trial. They have such shame that they fully jump on board, sometimes spearhead their child's innocence fraud campaign. There's a great picture of Rodney Reed's mother carrying a sign that says, my son Rodney Reed is innocent. His innocence fraud campaign is on its last legs. I think it has talked to Lisa O'Brien or texted her. Says it has one more motion in Texas. He's on Texas death row for the murder of Stacey Stites.
Had fresh damage. She openly questioned if she hit John O'Keefe, and prosecutors say she left him a voicemail that night saying she hated him. Those are some of the facts being used against her, but Reed's parents and thousands supporting her say there's so much more to this story that doesn't add up.
They say thousands are supporting her, and then cut to the actual courthouse where there's like maybe 100, a couple hundred at most supporting her. Thousands are supporting her. She's fighting for her innocence, guys. Their fight sounds so noble, doesn't it? Doesn't sound like something you want to join. Karen Reed's fight for her innocence.
She's from Taunton with a career in finance. He was a Boston cop from Braintree.
I really don't want to be in the picture.
Get over here. Karen Reed's parents say she and John O'Keefe became serious in 2019, right before the pandemic.
They just seem to...
What is Karen Reed wearing there? Just to go back. This is a clip I didn't remember until I saw it again today. What is she wearing here?
Was
Hold
a
on.
Boston cop from Braintree.
I really don't want to be in...
What is that? Is that a bathing suit? Did he decide to strip off and she decided to come in with like her t-shirt and underwear? What the heck is that? What is going on there? Is that a spontaneous moment on vacation with no bathing suit?
Get over here. Karen Reed's parents say she and John O'Keefe became serious in 2019, right before the pandemic.
They just seem to be in a happy place, you know, yeah.
And spending a lot of time together?
Yes. Yes.
Vacations together.
Yep.
Going out together.
If the relationship had become toxic by January 2022, as prosecutors allege, it's not apparent from this snapshot in time. At CF McCarthy's in Canton, they laugh at...
Right. It's not apparent from this snapshot in time. Look at her arm. John O'Keefe has his arm very warmly around Karen Reed, and her arm is just at her side. This would be the moment that you would put your arm around your lover at this point, right? Not Karen Reed. So, I mean, you can see that their tensions. This is what they're using to say that things were great between them, because he puts his arm around her for a second and while she stands there coldly. Not a great example, Ted.
An embrace during a night of heavy drinking. According to police, Karen would back over John and leave him for dead in a snowstorm 2 hours.
Right, they keep saying heavy drinking. Sure, it was heavy drinking. But like I said, I don't attribute this as an accident due to alcohol the way others do. I think, if anything, that she was fantasizing about doing this beforehand. Why I think that is because it's by proxy. You know, you notice the way Karen Reed confesses to everything is like, I don't know where John is. She just like puts it out in there that he didn't come home. He could have been hit by a plow. I could have hit him. Somehow she's very concerned that he got hit somehow, right? So she puts that out before she says, I hit him. This is my fault. She has other people dial. It's always like 1 degree of separation and always a little plausible deniability. What's a great way not a great way, but a way that you can deny it? Hit someone with your car. It was an accident. I didn't mean to do it. It just has that Karen Reed one level of deniability behind it. So a gun can be traced back to you. You could injure yourself, leave all sorts of evidence with a knife, but a car, and it wasn't really the car that was his injuries from the actual weather became a weapon. So all those things. She knew he didn't regularly wear a coat. She had to think more than once, well, you know, if he ever gets caught out in the cold, it's over for him. So that's where I go with this, more towards a premeditated murder than something that just happened by accident because she was so drunk. I've seen nothing in that says accident. How do you ignore your infotainment system flashing at you, warning you, you're going to hit something, and no, she did not have the automatic braking feature that automatically brakes. She had automatic brakes, which is very different than that automatic braking feature in her infotainment system that's connected with her camera. So when the moment she's about to hit something, it brakes.
Hours later, prosecutors say it happened outside the Canton home of another Boston cop named Brian Albert. Karen says she dropped John off there for a get-together. During your first discussions with Karen, did she believe she may have hit John?
No. She felt she struck something. She said, Dad, I think I struck.
So this is Heisenberg, really smart audience member, pointed out to me, and I missed it. I felt I struck something, and he or she is so right on this. That's experiential memory. She's remembering the moment of impact. You would literally feel it. She would literally be feeling it in her car. I felt I hit something. She would feel the moment of impact. She would be jolted herself in her car, even in her luxury, going 24 miles an hour in reverse, her foot 75% on the gas pedal, never once touching the brake. When she finally did hit John, she would have felt it. I felt I hit something.
John?
No. She felt she struck something. She said, Dad, I think I struck something. I said, what do you mean? Right? This was in the hospital. Right? He says, I remember, all right, backing up and hitting something.
Police find damage to the passenger side taillight of Karen's Lexus LX 570. How the damage occurred is in dispute. The Reeds believe it happened when Karen backed out of John O'Keefe's driveway, hours after police say she hit him. Here's the video.
She backs up to go out and search for John O'Keefe, and that's how that vehicle was damaged.
In court documents, prosecutors say the video only shows Karen coming close to John's car, and no fragments or pieces of a broken taillight were discovered in John's driveway.
Look at it frame by frame. And you tell me whether or not the O'Keefe vehicle, the left rear wheel, does not jetson forward upon impact and returned to its previous position.
Police did discover pieces of taillight where O'Keefe was alleged.
Well, you can't see the wheel jetsoning forward or backwards to its previous position. That is such a love tap of the vehicle. I mean, really, such a minor. And this is where she learned her deceptiveness. Had to be one of the places from her father. Look how deceptive this is to say. I mean, you have to watch it. It's not noticeable, and there's no damage left. And you can see her taillight is damaged there in that picture. It lights up red in the Ring camera video because it does that, but you can still see the damage in the back.
The vehicle, the left rear wheel, does not jetson forward upon impact and return to its previous position.
Police did discover pieces of taillight where O'Keefe was allegedly hit, but the Reeds say it wasn't until after Karen's SUV was in the custody of law enforcement. State police reported towing the Lexus to the Canton police station at 5:30 p.m. Nathan Reed said,
This is a mistake by the police because of the time change difference where they said 5:30 when it was much earlier. And Karen Reed's brother is right. It was at 4:16 that they got the vehicle, but the CERT team arrived a little before 5. So there was no time to plant the evidence. This was a really damaging part of Karen Reed's trial for Karen Reed, in my view. When you saw her car, when the CERT team arrived and when her car was being hauled off, there was no time to plant the evidence. They just didn't.
this daylight video from his dad's house shows the car was taken more than an hour before that.
They confiscate Karen's car at my parents' residence in North Dighton at 4:16 p.m.
So this is a really important part of innocence fraud, taking advantage of any kind of human error at all and capitalizing on it. So making the minutia of cases really big and totally ignoring the strongest pieces of evidence. So you're creating a warped view of the case. So now the things like the mirrored Sallyport video is hugely important for some reason, because that's when the planning occurred, that they had to mirror the video, which had it been the other way, would it have made any difference? What advantage do you get with mirrored video is what I'm asking.
And somewhere in the neighborhood of 5:30, 5:45, Mass State Police CERT team comes back to the scene. They search the scene then with 2 feet of snow, and pieces of a tail lamp are found on top of the snow.
The Reeds also question John's injuries as seen in autopsy photos. They say John appears to have dog bites on his arm. The defense theory is that O'Keefe was beaten inside the Albert home and attacked by the Albert's German Shepherd. Brian Albert's attorney declined to comment.
Our investigators also have found multiple people who have been attacked by the dog. I think
they're investigators. Who are the investigators? Karen Reed herself? From the imagination of Karen Reed? The dog didn't like other dogs and was given away.
John O'Keefe entered that house, was sucker punched, a fight ensued, and he was overwhelmed.
Wow, wow, what a liar he is. I want to see William Reed up on the stand. He's inserted himself into this case. He's convinced a whole lot of gullible people that she's been framed and is innocent. Get him up on the stand under cross-examination. Strangely, I don't think that will ever happen. But it should. In a fairer world, it would.
Prosecutors call that theory a fanciful conspiracy. According to the Norfolk
Yeah, that's some fanciful fiction right there. Guys, totally absurd. from the mind of Karen Reed. She says she's describing this is what she tells Gretchen Voss, that she was describing the wounds to her mother, and her mother figured out if it was a dog. Come on. It's just another nonsense story. Because Karen, she always puts it on someone else, right? Which is why she had Kaylee call Jennifer McCabe. She got 2 marks to find John with her so she could, right? So she could pass it off, make them the culprits. Capitalize on any human frailties and weaknesses that they had.
DA's office, 8 people inside the home and 3 more outside had testified that O'Keefe never entered. The office says GPS data from O'Keefe's phone backs that up. And the medical examiner who performed an autopsy on O'Keefe found no signs of Mr. O'Keefe being involved in any type of physical altercation or fight.
If the events happen the way Karen's attorneys say they did, how many people would have to...
So premeditation does not have to be planning out months ahead. So when I say premeditated, I think she could have been fantasizing about some kind of retaliation. John O'Keefe tried to kick her out of the home. She wouldn't leave of his home, before this. And premeditation can be minutes, can be hours, seconds. But I don't think it was an accident. I don't think she reversed with her foot 75% on the gas pedal by accident, with her infotainment system beeping at her that she was going to hit something. I think that's a hard pill to swallow. And anybody else who says it's manslaughter and this was just an accident and she didn't know that what she did, driving home, screaming at him, I hate you, etc., etc. I think they're in la la land. Either they are so enmeshed and put their own face on Karen Reed's action, meaning I could have done this. I've driven drunk. I've done this. I've had arguments with my boyfriend. Or they're in la la land and don't have a good grip on human behavior.
To be involved in the cover-up.
My sense is that there are a handful of people, influential people, who know what happened. And ultimately, will resolve these issues. My daughter will be free. That's what I believe.
Are you confident?
Right, free but not exonerated. My daughter, she's free now. There's a handful of, what did he say, influential people, which is exactly what they did. They went to influential people to get a federal investigation into the police officers who had the most knowledge on Karen Reed's guilt and do an investigation into it to make it look like, just make it look like something's amiss here. Something's not right. Something isn't being done by the letter. They don't have to come up with anything. Just the investigation is enough for the Innocence Fraud campaign to cast doubt on any charges against Karen Reed. And they knew that. And it was also an intimidation factor. Drop the charges. We have a federal investigation going into your officers who are going to have to be witnesses in this case. And lo and behold, if they did not find embarrassing text messages and inappropriate text messages by Michael Proctor, and they made much of that because they didn't have much else. They had a dog bite expert, a plow driver whose testimony looked like it was rehearsed and fed to him with poor eyesight, and a dog bite expert who looked like she was a true crime fan who wanted to get herself in and get herself paid by a high-profile trial. The Commonwealth is objecting to her being an expert, talking about the dog bite expert in the next trial. Hopefully, I think they might get that, get her thrown out as a witness, because Judge Cannoni barely wanted her to be a witness first time around. And second time around, both the evidence can both be narrowed and expanded in scope, because what Judge Cannoni is thinking about this case through the viewpoint of a juror. And let's not get in a lot of evidence that's going to confuse the jury and that's going to take the jury onto strange conspiracy lines of thinking that's not supported by the evidence. All we want to do is have a jury look at the evidence presented and make a decision, and not think, what if something really improbable might have happened that's not supported by any of the evidence.
Confident of that as well?
Yes. Yep.
Is Karen that confident?
Yes. Yeah. We are.
The Norfolk County DA's office is now publicly...
Well, they don't lack confidence, this family. That's for sure. But does anybody remember their great race to the taillight? Karen and her father? Immediately upon getting out of the car, they raced to the taillight to check it out. Anybody remember that?
You want to pause right there, please. Now, the Sergeant Mechanic, from this particular point of the video, do you recognize the vehicle that was just pulled into the driveway?
Yes, I do.
Is that the same driveway that you had walked up from the street to the house in Dayton on that morning?
Yes, it is.
As far as the vehicle is concerned, what do you recognize that vehicle to be?
That would be the Lexus SUV owned by the defendant, Bear, Massachusetts registration 3 GC 684.
I'm going to take the press right.
So this is Yuri the Machine Buchanan. The police officer investigated this case alongside Michael Proctor, talking, being questioned.
This woman, if you could pause right there. Two individuals just exited that vehicle, is that correct, Sergeant?
That's correct.
Do you recognize who those individuals are as far as who they are, from what part of the vehicle they exited from?
Yes, the passenger side exit was the defendant, and then the driver's side vehicle was Mr. Reed.
That'd be the defendant's father, is that correct?
That's correct.
Just going to see the friends again.
So where are they going? They don't want to go. They want to go right looking at the back taillight. That's where they race to the taillight. Check out the taillight, what condition it's in. Unreal, right, guys? How did it? All right, I'm back. I think my computer just froze. So that is the race to the taillight. What else do I have? I think that's pretty much what I have to show you guys today. Let me hit your comments before I go. A lot of negative comments about yesterday's episode. It was so boring. I'm so awful. those kind of things.
We got you coming. You had something to say. You were insightful. Oh, so clever. So Roberta's going to read your comments. Hey, Roberta, read those comments.
Lee 9103 says Sonny Slaughter is not a defense attorney. Thank you, Lee. Quite the opposite. She was the expert on I was going to say Law and Crime, but what I meant was Court TV yesterday. I said she seemed like a defense attorney, but she's not. Quite the opposite. She has a consulting firm. She used to be law enforcement for Homeland Security. She's an instructor for federal law enforcement. They called her a police expert or law enforcement expert. So that sheds some more light on that. Thank you. Ellen Pendergrass says, think your point about Facebook the other day made me glad that I never did Facebook. Yeah, I'm terrible at Facebook, but that Karen Reed is a Facebook aficionado. That is where she found a lot of the evidence, pictures, private pictures. That became evidence in her case. So she looks for personal pictures, embarrassing pictures, but seriously wonder how many Erders come out of connecting on Facebook, but good connections outweigh the bad, I hope. Yeah, I think it's Karen Reed who got in touch with John O'Keefe. At one point, she blocked him as a friend and then added him. That's all in the discussion that day. Facebook comes up in the text messages between Karen Reed and John O'Keefe. He's like, you blocked me on Facebook. She's like, oh. Markel Moon says plenty of video evidence against this jerk, meaning Aidan Carney, as well as text messages counting on this judge to serve justice. Hope so. So actually, before I go, there's a pretty interesting part of the actual Commonwealth's renewed motion. Hold on one second. Guys, let me fish it out. I thought I brought it up. Oh, I did bring it up. Hold on one sec. Please hold. So there's the Boston 25, and then there's this. And I just wanted to read this background. On September 27th, 2003. So this is going back to Gretchen Voss. And this is on Judge Cannoni's decision to allow in memorandum of decision in order of Commonwealth's renewed motion for all audio recordings, interviews, notes, emails, text messages, and voicemails in the possession of Gretchen Voss and or MetroCorps. And she's allowing it. You can see on the bottom there, allowed. But the background here is interesting. On September 27, 2023, Boston Magazine published an article entitled The Karen Reed Case in Canton, The Killing That Tore a Town Apart, written by Voss. The article details, among other things, the events leading up to the charges against the defendant and those leading to the defendant's suspicions regarding an alleged cover-up, LOL, that's me saying LOL, as well as the defendant's thoughts and opinions about the investigation into O'Keefe's death. Well, it wasn't a death, we know that. Voss has interviewed dozens of people for the story, including the defendant. She interviewed the defendant 3 times. For 2 of the interviews, which were conducted on June 20th and 13th, on the record of interviews, the attorneys were present and the interviews were audio recorded with the consent. right? So this is all the stuff we know. But this is like the legal issues. That basically she's not a confidential source. And Boston Magazine, so this is where it gets pretty interesting. Additional arguments against disclosure. Boston Magazine asserts several other arguments in opposition to the request for unredacted audio interviews, as well as the additional records sought, Voss's handwritten notes of any conversations between she and the defendant, and the emails, text messages, and voicemails between the defendant and Voss and or Boston Magazine. The court finds those arguments unavailing to the extent that Boston Magazine argues the Commonwealth's motion should be denied, again based on Voss's fears for her own safety and the continued harassment of her and her family. The record does not show that Voss continues to have such fears or experience such harassment. Because she showed up at the rolling rally, no fears. She showed up at the trial, no fears, no bodyguard, seemed to not be harassed at the trial, etc. The Boston Magazine, anything that's happened in her personal life has not persuaded the court that if she submitted it. The Boston Magazine article written by Voss was published over a year ago, and the harassment detailed in her January 17, 2024 affidavit occurred in the months immediately following its publication. Notably, Voss has not filed an updated affidavit stating that she is still subject to harassment or fear for her safety in support of the opposition to the renewed motion. So I thought that was interesting. Boston Magazine contends that producing the records would be unduly burdensome. It is unclear to the court how having to now produce unredacted audio files as opposed to redacting hours of audio would be unduly burdensome. So they're saying, like, look, the burdensome part was having to redact all this stuff. Just hand me what you have. This is the opposite of burdensome. The production or the additional materials will appear to be readily available in some format of which Boston Magazine asserts do not exist, would also be unduly burdensome. So they say that it's the Commonwealth has expanded its previous request without cause, and they're rejecting that. So there's the order. Pretty interesting, but there's also another interesting part of the story where Gretchen Voss is in line with Aidan Carney. Let me find it. Hold on one second, guys. Here it is. Gretchen, and this is from X, Aidan Carney's. Gretchen Voss decided to get ratchet with me today in the media line. Here's what she really thinks of the Keefe families and the Dougals. But that was before David Trav got to her with her burger. So she had said that after Morrissey's statement, you guys all remember his statement where he went, the attorney general went on camera and said this harassment of witnesses has to stop and there's no conspiracy, essentially. And Gretchen Voss wrote, this will be, I'm paraphrasing, but a great comfort to the witnesses. So Gretchen Voss writes, the Jersey in me was this close to asking Carl's wife, who spent the entire hearing staring at me and rolling her eyes with this disgusting smirk on her face, to take it outside. She wasn't so tough with you after. Nice work, all between us. Of course, Aidan didn't keep it all between us. He put it on his X account. Oh, wait, she's with CAA in New York. By the way, the hostility directed at me from the O'Keefe side at court was insane. I had introduced myself to Carrie before, and she said they wouldn't speak to me if I was writing about the blogger Dagger Stares, even from Mrs. O'Keefe, who knows the huge tan bald dude in black shirt who stood. Oh, do you know who that is? So the O'Keefe family knows that what Gretchen Voss eventually wrote was Karen Reed's narrative. And they were right about her. She protected, I just don't look kindly on Gretchen Voss protecting Karen Reed under the guise of, journalistic integrity, some journalistic reasons. She's not a confidential source. There's no reason why she shouldn't have handed all this over years ago. So that's what I have for today. Please hit the thumbs up, subscribe to the channel, and I'm off tomorrow, but I'll be back Saturday at 6 p.m. Eastern. I'll see you guys then. Going out with my hit song, I Hit My Boyfriend With My Car. See you Saturday.
I hit my boyfriend with my car. It wasn't an accident, but with lying lawyers I'll go far. Lying lawyers and witness harassment, I'll avoid prison. It was snowing. I pushed the pedal down, hit him hard. Now the legal system a clown. Innocence fraud campaign to save my skin. Making money, truth is my second victim. Carry, Jen, like John, you were my mom. My innocence fraud campaign is my biggest hit yet. I hit my boyfriend with my car. It wasn't an accident, but with lying lawyers I'll go far. Lying lawyers and witness harassment, I'll avoid prison. It was snowing. I pushed the pedal down, hit him hard. Now the legal system a clown. Innocence fraud campaign to save my skin. Making money, truth is my second victim. Carry, Jen, like John, you were my mark. My innocence fraud campaign is my biggest hit yet.